Sorry, Mr. Omar. Do you know the Omar in Soweto?
Omar in Soweto? No.
Okay. You don't know the famous drum reporter who exposed the atrocities perpetrated on black peasants? They were farming potatoes using their hands.
Was it Omar?
Yeah.
No, I'll follow on that.
Famous gentleman.
Yes.
I schooled with a daughter, Suzette.
Is it?
Pretty girl.
When was that?
Hello?
When was that?
Suzette, I schooled with her 1960.
Oh.
In Madibane High. And the father, but a wee reporter, he was a reporter, as I say, drum and zong. And he's the guy who trained Abu Net Nakasa. You must know Net Nakasa.
Yes, I've heard.
Yeah. They hounded him out of South Africa and he went to teach in Swaziland. I must, SBs. You must ask your parents about the guy.
No, I will. It shows that we spend most of our time in Zululand, so...
Is it?
Yeah.
Okay, no problem.
Thank you.
It just struck me.
Listen, what Nxumalo did can never, ever, ever, ever be undone. You know, I always say you can never misquote silence. However, in this case, we can always quote Nxumalo for what he did to my Lord, who said the defense team never, during Zungunaiza's cross-examination, questioned him with regards to Usinako and the firearm and Dondon. That's what my Lord said, and he didn't say maybe, possibly. No, he was affirmative. And then Nxumalo's Tulele Nxumalo Gazwite, okay, Uzwite Galanga said, hold my beer, okay, hold the line. I can check the record. In 2023, this was actually done by my learned friend Umnisi Wemvula, and of course myself too. And he also cites a date, which is early October 2023 as well, which leaves my Lord thoroughly embarrassed, and he mumbles. You could barely hear it. Some of you left the comment in my previous video that you hadn't actually heard him say it. Trust and believe he did. I must have made a mistake. Those were the words of my Lord. Now, this clip that I just played right here, where he's just off topic, okay, it's supposed to be Mshololo starting her her heads of arguments with regards to Baloyi's outrageous attempt. We'll get into it. But my Lord starts with this distraction tactic, okay, to soften up Nxumalo. Oh, do you know the Nxumalos in Soweto? Oh, I went to school with their My Lord, what are you doing? What are you doing? You are not going to alter the record. We heard you loud and clear. You made a mistake. This is such a shame. And it's okay to make mistakes. It's also okay to apologize for your mistakes, especially when you undermine the people that have found you out to be a fraud. In this case, for example, and it's on record. So may the defense continue with their stances of putting things on the record, because as you all know, Baloyi likes to go back to Ngomezulu's record and say, well, Advocate Ngomezulu said this, may his soul rest in peace. He's not here to stand up for himself. So the defense are working tirelessly to ensure, especially in this heads of argument, they keep bringing it up, that, yeah, in case I'll be misquoted later. So anyway, I wanted to start off with that highlight that look at my Lord trying to distract the record. We see you. We see you. But with that said, hello everybody. Welcome back to another Mzansi Unfiltered edition. I'm excited to jump into Mshololo's heads of argument, and she's showing off and showing out in this one, because she does not submit any documents. She is submitting her heads of arguments from the bar. And just in case you don't know what that means, it means I am not reading off a piece of paper. I'm an expert in this topic, and I can talk off the cuff.
I will address from the
Well,
I'm just asking.
let's see how she does. Let's get into it.
In response to the application by the state, my Lord, I would like to respond as follows. Generally, my Lord, the confession, in terms of section 217, it's inadmissible against the co-accused. That's the general rule, which is also confirmed in the case of S versus Molimi, 2008, volume 2, SACR 76. It's a constitutional court decision.
Yes, by Nkabinde.
By Nkabinde, my lord. It's a standard rule, which confirms the provisions of the criminal procedure and the constitutionality of those provisions.
Right.
That the use of a statement against the co-accused is unconstitutional, my lord. In this case, my lord, this honorable court has ruled on the admissibility of the statement that is an issue. And when the state introduced this statement, informed this honorable court that they intended to introduce the statement which was referred to as a confession, and the other one was referred to as a pointing out. And when a ruling, my lord, was made, this court, this honorable court, was guided by the provisions of section 217 and section 219 of the Criminal Procedure Act. And even the proceedings of a trial within a trial proceeded along those applicable provisions of the law. At no stage wherein it was indicated that such statements were the executive statement. And even when the ruling was given, my lord, it was not given that this statement is ruled admissible as an executive statement, because it was not tried as such. And the trial within a trial was not done for the purpose of admissibility of an executive statement. So the submission that has been made by the state, my lord, which I would want to also read because it is contained in the decided case which my learned friends have referred this honorable court to, the case of Mhlongo and Nkosi, my lord. It's a constitutional court judgment on page 39. I'll just read the two lines. Yes. Common law exception. At common law, there is an exception to the exclusion of extracurricular statement of co-accused if the statement constitutes an executive statement. Close quote, my lord. If the statement constitutes an executive statement. The main issue to be decided, my lord, I submit, by this honorable court, is whether the statement made by accused, let me not say whether the statement made, because one day it will be said that I said the statement was made, whether the exhibits.
Who will say this?
The state, my lord.
Oh, the state.
Yes, the state. They will be saying that, yes. Whether the statements contained in Exhibit GG, Exhibit FF, respectively, my lord, before this court, constitute executive statement. If they are no longer the confession, they are now executive statements, then this case is applicable. But if they remain the confession and the pointing out, it means then that this case is misplaced, because the statement that is before this court is not an executive statement. In other words, my lord, the state is doing what is called, or what is referred to as trial by ambush.
A trial by ambush. Ladies and gentlemen, this is not the first time we have heard the word, and neither is this the first attempt of a trial by ambush by George Advocate Baloyi. I'm just curious, how many of his previous cases has he won by a trial by ambush? Because here in the SENZO MEYIWA trial, each time he tries it, they clock it. They clock him. And in this case, Mshololo, like I said, is speaking from the bar, and so far, so good, okay? Because there's a difference. You guys know that I've already told you Onqumalo presents from reading, and although what he's prepared is great in reading, it would have twice as much impact if he presented it in terms of more engagement with my lord. As you can see, Mshololo, every turn is engaging my lord. So here she says it's a trial by ambush because you, my lord, you see, you bring my lord to attention and you tell him that you already made a ruling. You ruled the confessions admissible. You called them confessions within a trial, and the record also shows them as confessions. So where does Baloyi get off suddenly coming forward with an application and calling these executive statements? You know, Baloyi is quite a hilarious man. He spent 3 weeks making Muzi tell us over and over and over again about the pointings out with Ukhatebe and how the photos were taken, and he would cross-examine him over and over again, trying to catch him out, only for him, Baloyi himself, to go jiggy. Well, my lord, it was actually an executive statement. Kudos to the defense for catching this nonsense out, okay? My lord is in a tough spot. He's in a tough spot because he ruled the confessions. Yes, confessions, not executive statements. So how is he going to wiggle his way out of this one? Shout out to Mshololo for calling this out a trial by ambush. Let me play you the clip where she said this before. Here goes.
I received another bundle of documents from the state, of which I have not been able to read them. I can see also the email was sent last night at 2300 hours, of which I was not told not to sleep and wait for this email. Unfortunately, I couldn't read it overnight. As a result, my lord, I would like to place it on record that this is a trial by ambush, my lord. Yesterday I had, as a pointing out, that after the state case has been closed, the state makes submissions that such statement be referred to as an executive statement. My lord, there is a difference, a huge difference between the two statements. I would highlight just few differences between the two statements. Confession is made before a peace officer. Pointing out is made before a peace officer. Executive statement is not made before any peace officer or a magistrate, my lord, in terms of section 217 and 219 respectively. The point I'm trying to make, my lord, is the difference between the two and the circumstances under which these two statements will be made. Executive statement is not made before a magistrate, it's not made before a peace officer.
No, I think Mshololo is showing off her expertise now. She's going overboard. How is she expecting Brigadier Nicholas Gininda of the prosecutorially led investigation to know such a simple difference between a confession statement and an executive statement? I mean, the whole plan of the confessions was to ensure that they become admissible, and they made sure that they were done in front of a peace officer and also in front of a magistrate. They did it twice to make sure it's double measure, that there's double measure and there's no room for any errors or the confessions being thrown out. And you know, within a trial, they celebrated as my lord allowed the confessions in with a ruling. And now Mshololo is now talking about, well, there's a huge difference between an executive statement and a confession. You see, an executive statement cannot be taken by a peace officer or a magistrate. Listen, at this point, she might as well have dropped the mic and sat down. Ooh, how I would have loved to see Brigadier Nicholas Gininda's face as that was being said. But even better, cameraman, Baloyi is inside that courtroom, and the camera does not move in any way, shape, form in Baloyi's direction. Why is it giving paid media? Why is it giving media was instructed not to do so? Because we've seen that camera move. We've seen that camera align itself with random people in the courtroom for unnecessary reasons. But in this case, when it must show us Baloyi, the camera decides not to move in that direction no matter what. Drop it too in the comment section if you notice that as well. Is the media captured inside Judge Ratha's courtroom? Let me know in the comment section down below. But That was brilliant, Mshololo. I loved it. We've got to drop some flowers too. Let's continue listening on.
That's the difference. Then now the statement, my lord, is before this court. Had we been informed from the beginning that these are the executive statements, my lord, the accused person would have defended themselves differently and appropriately. And as a result of the misplacement of this submission, the accused rights to the accused rights to a fair trial has been violated. Even if it has not been violated, my lord, but it will be violated if the court allows the state to use the statements contained in Exhibits GG, FF, and HH against the co-accused. Their right to a fair trial will be violated, my lord. And it will render this trial unfair. And also their right to equality will also be violated. As a result, my lord, it is my submission that this court should not allow the state. I don't know the correct term to put, my lord.
To allow?
To allow the state to fish, you know, because the state is now saying it's a confession at the beginning. During the trial, it's an executive statement. Alternatively, it's a hearsay statement. It's a hearsay evidence. We're running 3 parallel regimes. And which one do we need to defend? The status of the evidence that is presented before court is very crucial, my lord, so that the accused will be able to defend that evidence appropriately. Even if, because the problem, if that is not defined properly, the classification of evidence that the state is intending to lead, or that the state is leading, is that at the end of the day, the defense will be expected to make submissions on the admissibility of such evidence for the purpose of conviction now. And then if, my lord, the evidence is introduced as a confession, during 174 is introduced as executive statement, then our arguments, it is not clear as to what is it that we need to defend regarding that statement when we are doing the assessment of evidence now, my lord. I submit, my lord, with due respect, that the statement, these 3 statements, as they have been ruled, they do not amount to executive statements. The case of S versus Mshololo, my lord, and S versus Nkosi, it's a constitutional decision case, my lord. My learned friend has referred to it. It's a 2015 well-known case, volume 2, SACR 323. And on paragraph 39, my lord, on paragraph 40 of this case. Open quote, my lord, on paragraph 40. It's a judgment by Theron AJ. It is not necessary to determine this issue. The facts do not arise. The extra crucial statements here were not executive in nature as considered by the state and will not fall under this exception. Determining this matter without any factual metrics to guide our understanding is unnecessary and undesirable. This question was not fully ventilated before us, and we thus have insufficient information to make a determination in this regard. We therefore thank His Lordship for the indulgence given to us so that we'll be able to ventilate this proper, my lord. To be able to make differences, make submissions on the statements that we're talking about. This paragraph, my lord, says it is not, the exception that the state is referring to is misplaced because the extra crucial statement here that we're talking about now, in this case, my lord, they are not executive in nature. Therefore, the exception is not applicable in this case. Because the statements that we're talking about, they are not executive in nature. They were not meant under the executive or for the executive purposes and the intention thereof. The state indicated that those statements were made under the provisions of Section 217 and 219 of the Criminal Procedure Act. And therefore, the exception that the state wants to rely on does not apply to the statements that are before this court. And they cannot be used against the co-accused, my lord.
I think that Baloyi should be embarrassed of himself. This is the bare minimum. And as Mshololo said, there's 3 parallel versions that are running here by the state. That it's an executive statement, whenever it feels like calling it an executive statement. And then it also wants to call it a confession whenever they want it to be a confession. And then they also want it to be hearsay evidence. Which is which, and which must the defense and the co-accused prepare their defense based on? They seem to be, and by they I mean the state seems to be changing their versions. Even though the state case has closed, they're changing their versions like the Cape Town weather. And this is an embarrassment, an atrocity to justice. I'm going to end this video right here, but I cannot end it without placing a reminder of what the late Advocate Joshua Ngomezulu said, because I think it's relevant in these trying times. Here goes.
Accused number 1 was not there. They're busy now. That's why one will be tempted to say they are cooking. They are manufacturing day in, day out, so that it can fit what the state wants to do. Because I can tell this court now, they don't have a case. I'll say this slowly so that I'll be understood.
There are pages that are missing. And my lord, what is very bad in this trial is that the state is dishonest with this court.
Those are records that are relevant. I'm in possession of the 205s for Kelly Kuman. And the state, I'm going to show the state that there was no such a communication. That is direct evidence. I'm not sucking a thumb to say I'm looking for the number for Ntuli, for Mapisa, for whoever. I've got the records for Kelly Kuman on the date of when SENZO was killed. They're busy with 2018, 2021. We are not really interested. That's not our defense.
That is the first thing. And secondly, my lord, I hear the submissions of Mr. Ngomezulu, but
I must respond to what Mr. Blue said. I just wanted to say that is not correct. When we spoke...
When he says you consulted, he's not correct.
I did not consult.
Okay, fine.
Whatever information that comes after a full disclosure, after the trial has commenced, it's ambush.
Have you not heard when I mentioned 4629 with the time?
Another challenge, ma'am, is you're talking low. Ukhulumela phansi.
You are speaking very low.
What?